available if you are unable to use the first three options. Then if you can't, then you have to approach the Labour Commissioner giving reasons as to why you are unable to serve the documents via by handing a copy, or by sending a copy by registered post, or by sending it through or by fax. And then the Labour Commissioner will give you, if it's by email, will tell you, okay, give email and give me proof that, attach proof that the email has been received. Or sometimes, maybe it's a lot of employees, and now the company wants to serve all of them and you cannot. Maybe afforded an opportunity to serve them via newspaper and so on, or through the radio, and then the Labour Commissioner will then give you the directives as police, the commission of oath to certify the document, because that is an oath that you are taking.
Okay, thank you very much for that detailed explanation. I hope now the viewers find it easier and know what is required when you are filling in those forms that were just currently presented on the television screen. So welcoming into the conversation right now, we welcome Mr. Mazambo. In limine, raised before or during proceedings, and how are they dealt with?
Thank you for the question. Initially, preliminary issues. Maybe first let me start by emphasizing what preliminary issue is. Preliminary issue is actually, it's an element or discrete elements that is, preliminary issues, there are actually two. They are divided in two. There are those that can bring an action to an end, and there are those that can only delay an action. For example, let me start with action. We have preliminary issue of prescription. We have preliminary issue of res judicata. There we have preliminary issue of representation. We have preliminary issue of, for example, uniformed officials like police and soldiers, for example. Yeah, let me start maybe by just trying to give emphasis to any of these preliminary issues. Jurisdiction. As we all know, our country is vast, and we have different jurisdiction. So, for example, if a dispute arose, maybe the company is based in Otjiwarongo, for example, and then the party, one of the party who wish, or an aggrieved party who refers the matter, who wish to refer the matter to office or to the Labour Commissioner, then comes to Windhoek and refer the matter to the Labour Commissioner in Windhoek. That in itself, it becomes an issue, because the jurisdiction, Windhoek and Otjiwarongo, these are two different jurisdictions. So, knowingly that the Labour Commissioner is actually is created by an Act of Parliament, which is a creature of statute. Anything that has to be done should be within the parameters of that statute. So, the officials or the commissioner, Labour Commissioner in Windhoek, cannot entertain that matter, because it is hailing from different jurisdiction. So that in itself, once one of the party, for example, if the respondent raised that, it disposes of the matter. Okay. Prescription, for example. Prescription, I can give an example of a dispute. If a dispute, for example, a dispute of unfair labor dismissal is referred to the Labour Commissioner, the Act makes provision that a dispute of unfair labor dismissal needs to or should be heard, must be heard within 6 months. So if an aggrieved party or an applicant refers the matter after 6 months, that in itself already is beyond the prescribed period that is provided for by the law. So it disposes of the matter. Res judicata, for example. Res judicata is, it actually happens in such a way that if a dispute is referred to Office of the Labour Commissioner and it was heard, adjudicated upon, and the decision was already made, and then maybe after some time one of the parties is not happy with with the decision that was made by the arbitrator, then goes back to the office of to the Labour Commissioner and refer the same dispute on the same facts, the same party, at the same forum. That in itself, the arbitrator do not have mandate to entertain such kind of dispute because it was already heard. Since it was already a decision was already made, it disposes of the matter. And maybe I can give an example of another preliminary issue is that of private arbitration. Building on what my colleague Ms. Parker earlier stated. Private arbitration, some companies, they have it already in their policies that should their dispute arise in their workplace, the policy already clearly states that a dispute should be referred to a private arbitration. So that in itself, because like I indicated from the beginning that the Labour Commissioner is governed by an Act of Parliament. So it deals with statutory arbitration. There is private arbitration is out of, it's not within that space. So it already, if the policy of the company clearly or explicitly states that a dispute need to be referred to private arbitration. So that in itself, it's beyond the mandate of the Labour Commissioner to entertain that matter. So that also disposes of the course of action. So these disputes or this preliminary issue that I've just spoken about, that I spoke about, are actually, they are called, they are preliminary issues in abatement. So, however, we also have preliminary issues that are dilatory in nature, such as preliminary issue of non-joinder, preliminary issue of non-joinder. Preliminary issue of non-joinder, for example, is that they deal with citation. Building on what my colleague, Mrs. Clarkler, indicated with, especially when she was explaining with the form. That form, it shows which party is, who is the applicant and who is the respondent. Okay, there are times where a referring party may cite a wrong party or may not necessarily cite all the parties. So that in itself, then one of the party or a respondent will then claim, no, you were supposed to cite the other party, because they have interest in the matter. So that's an issue of non-joinder. When that preliminary issue is raised in an arbitration, it does not dispose of the matter, but it only delays the proceedings because it can be cured. Rule 31 of the rules regulating conciliation and arbitration, it makes provision for that. It can be cured. And the issue of, for example, one of a preliminary issue that is dilatory in nature is, for example, they're actually not exhaustive. For example, the issue of discovery of documents. You see, when, like, our proceedings, just like in a court setup, our proceeding is, they are not meant to ambush each other. When you come to when you go to the proceeding that are done at the Labour Commissioner, you need to show, or either you need to discover all the documents or the evidence that you are going to use during your case. So
Okay.
both parties must have those evidence.
Okay, well noted.
Yes.
So we would just like to remind our viewers that our call-in lines are open, and should you be joining us via our social media page, you questions and queries there. You can join us on Facebook at the Ministry of Information and Communication Technology Namibia, or you can advertently join us on our YouTube page, which is MICT Namibia as well. You can kindly leave your questions there. Or you could kindly call us directly on our line, which is 061 400 397. Once again, you can call in on the line 061 400 397. So coming back to Ms. Sihlatla, what exactly is Rule 20 and its importance to the process? So if we could kindly just have the form as well on screen.
Okay, the purpose of Rule 20 is to curtail the proceedings. Rule 20 plays a pivotal role in our arbitration proceedings. And then it's a must that the arbitrator, after the parties have failed to reach an amicable solution at conciliation, must assist the parties to come up with a Rule 20 agreement. The Rule 20 agreement will assist the parties to concentrate on the issues that are in dispute and then park the issues that are not in dispute. For example, you will then have the first one is that you determine the facts that are agreed between the parties. For example, if the applicant was an employee of the respondent, and both parties agree that yes, this person was employed by this respondent, then you just write it down and say, this is an issue that is not in dispute. The applicant was an employee of the respondent. The salary was this amount, was employed this date. The employment contract was terminated on this date. And for example, if the dispute does not concern either the procedural aspect or the substantive aspect, then the parties can say, no, we are only challenging the substantive aspect, or we are only challenging the procedural aspect. Then one will be like a non-issue, and it will not be dealt with. Then the facts that are in dispute, for example, the applicant will say, no, my problem is just that the company did not have a fair and valid reason to dismiss me. They have done well with all the procedures and so on. So my issue is just the reason and the fairness of such reason.
Okay, before you continue with the form, we do have a caller on the line, Shikwa from Windhoek. Welcome, Shikwa.
Hello.
Yes, hello. Do you have a question for us today?
Yes, I was asking this.
Shikwa, we cannot hear you properly. Could you kindly start from the beginning, please?
Hello. Hello.
Yes. Kindly state your question.
Do you hear?
Hello?
Yes.
Yes, we can hear you now.
Yeah. Arbitration allows you to make without
Shikwa, if you do have your TV or radio on, could you kindly switch it off and then we can continue because your line is currently interrupted.
Okay. I asked if the arbitration can decision while the applicant is involved. Is this allowed?
You'd like to ask if what is allowed, sorry?
The arbitration.
Shuka, could you kindly call us back because your line is not clear, so we cannot understand what you're asking.
Do you hear?
Your line is not clear. Kindly do call us back, please.
Okay.
Yeah, so getting back to Mrs. Shasha, did you finish your point on Rule 20?
Not yet.
Okay.
Okay, they also determine or they indicate the issues that the arbitrator is required to decide. Like, for example, they would say, we only want the arbitrator to decide on whether or not the dismissal of the applicant was for a fair reason or the fair procedure was followed. Then that is exactly what the arbitrator will have to determine. And again, if there is a precise relief claimed and if compensation is claimed, the amount of the compensation and how it is calculated. If the applicant, for example, the relief that the applicant is seeking is reinstatement, it must be clearly indicated that it's reinstatement. If it is a compensation, for example, the applicant cannot just claim, I want compensation of 1 million. The applicant must indicate how he or she arrived at 1 million so that the other party will be able to understand. And then the sharing of and exchange of relevant documents. You know, our proceedings are not a trial by ambush. You have to disclose, you have to share the documents. Because if you want, for example, to come and surprise the party at the proceedings to say, hey, I have got this document. The other party will request for time to go and study the document and also maybe prepare witnesses that will come and testify in relation to that document. Okay, sometimes, for example, there is maybe work that was done somewhere and the parties would want to go for an on-site visit just to go and show the arbitrator what transpired there. So they have to agree as to whether there will be a need for the on-site visit. And whether evidence on affidavit will be admitted with or without the right of any party to cross-examine the person who made the affidavit. Okay. If they agree to that, that will also be done. And they can also agree to say, we also want maybe to come up with other ways of how to minimize or to shorten the proceedings, or if they've got preliminary points that they would want to be attended to first, they can also indicate so. And it is very, very, very cardinal because it will curtail the proceedings.
Okay.
In a case that was supposed to have taken 20 days or 2 weeks, might end up taking like 3 days.
Okay, so we do have another caller on the line. So we do have Stephen from Windhoek. Hello, Stephen.
Yes, good afternoon.
Yes, good afternoon.
Okay, good afternoon from studio.
Okay, kindly state your question, please.
I was listening to the whole direction and the procedures there. My question is that kind of procedure a farm worker who been unfairly dismissed or illiterate, just let me say, just these illiterate people, really could they get a fair from Minister of Labour? Who's supposed to represent them? Because that needs to somebody who's articulating laws to write that kind of a case if that person is unfairly dismissed. How is there no way that you can accommodate farm workers and all these illiterate people who did not go to higher education? Because those ones are very complicated. You don't only need a lawyer as an assistant to it. You only need somebody who understands law.
Okay, Stephen, just to confirm, you'd like to find out how does the Labour Commissioner assist people, for example, who are illiterate and are unable to fill in the forms, for example?
Yes.
Okay, thank you very much for your question. Kindly stay tuned while you get your response.
Thank you.
Okay, any of you like to tackle that question?
We have got labor inspectors falling also under the Ministry of Labor, and they can assist the parties to complete the forms. Or if they approach any Office of the Labor Commissioner throughout the country, they can also be assisted. We have got administrative officers that can explain to them how the form should be completed. And if they've got also somebody who understands, because the forms are not so complicated, they can also be assisted by any other person, provided that even if the form is completed by somebody else, they must be the ones to sign the referral.
Okay, well noted. Just to confirm, did we finish the Rule 20? Were you complete with that?
Yes, in short, that is it. It's just to emphasize that once the parties go through Rule 20 and everything is done properly, that will shorten the proceedings.
Okay, well noted. Now going back to Mr. Mazambo, what is the outcome of conciliation and the outcomes of arbitration?
Thank you for the question. In short, the outcome of conciliation, especially in respect of dispute of rights. With conciliation, the outcome is either a settlement agreement or the dispute, or if parties reach a deadlock, the dispute is referred to arbitration. When, for example, this is with dispute of rights, if the settlement is reached, of course, the parties can draft their settlement agreement, or they can be assisted by the arbitrator.
Okay, if you could kindly just quickly hold your thought. We do have Shikwa back on the line. Shikwa, welcome. Yes, could you kindly state your question?
Yeah, I ask you arbitrator, because arbitrator, they are allowed to make a decision while they are not invited to the applicant.
Shikwa, okay.
Because one case I was registered to the Labor Commission, then we are going to reconciliation. Then from the negotiation, the arbitrator, we were waiting for the arbitrator, but they are not invited us to arbitrate. Maybe it took 6 months, and then later I just received the letter from the arbitrator that they make already decision.
So in short, what exactly is your question, Shikwa? Whether an arbitrator is allowed to make a decision?
Yeah, without invite
the applicant. Okay, yes. Well noted. So Shikwa, kindly do stay tuned. We will have an answer for you shortly.
Okay.
Okay, would somebody like to attend to the question, or would you like to finish up your previous thought?
I will attend to it as well.
Okay.
What normally happens is this. During conciliation, the referring party, the arbitrator notifies, or the commissioner notifies, set down the date for arbitration, or for conciliation, sorry. Then, during conciliation, the date that the conciliation was set down, if the referring party fails to attend the conciliation meeting, the referring party, which is the applicant, so the arbitrator will dismiss the matter. But if the respondent, fails to attend the conciliation meeting, of course, the arbitrator will then determine the matter. Of course, this is subject to the fact after the arbitrator has satisfied himself that parties were properly notified and they confirmed. Yes.
Okay, well noted.
So I think in that regard, it also responds to Shikwa's question.
Okay, it does definitely answer the question. If we would quickly go to Ms. Parker. So what happens if a party is not satisfied with the award or decision of the arbitrator? Does it end there, or what can be done?
Thank you. As my colleagues stated before, arbitration awards are final and binding on both parties. However, if a party is aggrieved by the decision made by the arbitrator, they have the right to approach the labor court and make an application to the labor court to have that award appealed or reviewed.
Okay.
And this is according to Section 89.
Okay, very well noted. Coming to Ms. Shlala, if you could just give us like a short answer as to what is the difference between statutory arbitration and private arbitration?
Okay, statutory arbitration is a quasi-judicial process. And with the statutory arbitration, the arbitrator is designated by the Labor Commissioner, and the Labor Commissioner is the one to determine the date, the venue, and the time the arbitration will be held. While with the private arbitration, the parties themselves, it's a voluntary process, the parties themselves will then determine who the arbitrator would be, but there would not be an arbitrator under or from the Office of the Labor Commissioner, because those are statutory arbitrators. I mean, they are arbitrators that deal with the statutory arbitration. And then they will determine on their own as to who the arbitrator would be, and they will also come up with the terms of reference that the arbitrator will give, and they will also determine the cost, because they will have to pay that arbitrator.
Okay, thank you very much. I hope that has been very educative for people who are needing that information. But that's all the time we have today here at the Government Information Center. So from me, Angela Situmbeko, and my production crew is have a good day, Namibia.